The packed courtroom fell completely silent yesterday as Supreme Court Justice Brett Kavanaugh struggled to find words. What began as a routine judicial oversight hearing transformed into a moment that legal experts are calling a turning point in constitutional accountability when Congresswoman Jasmine Crockett asked one devastating question that left the Supreme Court justice visibly shaken. "Justice Kavanaugh," Crockett said calmly, holding up a document that no one expected existed, "could you explain why you applied strict scrutiny in this case, but rational basis in this nearly identical case?" The question hung in the air as Kavanaugh's confident demeanor instantly changed. Committee members leaned forward. Reporters stopped typing. For several long seconds, one of America's most powerful jurists sat speechless. What happened next didn't just embarrass Justice Kavanaugh. It exposed contradictions in the Supreme Court's recent decisions that legal scholars say could reshape how we understand the Constitution. If you're tired of seeing powerful figures avoid accountability, hit that like button and subscribe, because Jasmine Crockett's masterful questioning didn't just win the day. It revealed a pattern that could change the Supreme Court forever. To understand why this confrontation has sent shock waves through America's legal community, you need to know who these two figures are and the stakes of their encounter. Justice Brett Kavanaugh, 59, has served on the Supreme Court since his controversial confirmation in 2018. With his prestigious Yale law education and years on the D.C. Circuit Court of Appeals, Kavanaugh has positioned himself as a strict constitutionalist who frequently emphasizes the importance of following consistent legal principles regardless of politics. Since joining the court, he has been a reliable conservative vote, particularly on cases involving religious freedom, executive power, and campaign finance. In public appearances and written opinions, Kavanaugh regularly stresses judicial neutrality. "A judge must apply the law as written, not as the judge wishes it were," he stated during a lecture last year at Georgetown Law. Consistent application of constitutional principles is the bedrock of our legal system. This commitment to consistency is precisely what would make yesterday's exchange so remarkable. The Congressional Judiciary Committee had convened a rare oversight hearing focused on the Supreme Court's recent First Amendment decisions. Such hearings are uncommon, as justices typically avoid testifying before Congress except during confirmations. However, amid growing public concern about the court's plummeting approval ratings and questions about its legitimacy, Kavanaugh and two other justices agreed to appear. Congresswoman Jasmine Crockett represents a different kind of legal expertise. Before entering Congress in her second term representing Texas, Crockett built a distinguished career as a civil rights attorney. A graduate of the University of Houston Law Center, she earned recognition for successfully challenging voter suppression laws and defending protesters whose rights had been violated. Unlike many representatives who rely heavily on staff for legal analysis, Crockett brings actual courtroom experience to the Judiciary Committee. Her questioning during hearings has consistently displayed a deep understanding of constitutional law that even political opponents privately respect. What most people didn't know before yesterday's hearing was that Crockett had spent months preparing for this moment. Working with a team of constitutional scholars from several top law schools, she had methodically analyzed every First Amendment decision issued since Kavanaugh joined the court. Her research identified a troubling pattern. "The Constitution doesn't play favorites," Crockett told a colleague before the hearing. "The same principles should apply whether you're a corporation, a religious group, or a protester." But that's not what the record shows. The stage was set when Chairman Jim Jordan announced that each committee member would have 5 minutes for questions. Few expected that Crockett's allotted time would produce what legal commentators are now calling the most substantive constitutional challenge to a sitting justice in modern history. The hearing room was filled beyond capacity. Additional spectators stood against the walls, while others watched on screens in an overflow room down the hall. The atmosphere was formal but tense as Justice Kavanaugh finished answering relatively general questions from several senior committee members. "The gentlewoman from Texas, Ms. Crockett, is recognized for 5 minutes," announced the chairman. Kavanaugh shifted slightly, perhaps expecting standard questions about the court's procedures or general philosophy. Crockett, dressed in a professional blue suit with a small Constitution pin on her lapel, arranged several binders methodically before looking up. "Thank you, Mr. Chairman," she began, her voice calm but clear. "Justice Kavanaugh, I appreciate your appearance before this committee today." She opened with a disarmingly simple question. "In your 2018 confirmation hearing, You stated that a good judge must be an umpire, a neutral and impartial arbiter who applies the law the same way regardless of who's before the court. Is that still your judicial philosophy today? Yes, Congresswoman, Kavanaugh replied confidently. Consistent application of constitutional principles is essential to maintaining the rule of law and the court's legitimacy. I'm glad to hear that, Crockett said, because consistency is precisely what I'd like to discuss today. She opened the first of her binders. I've reviewed all 37 First Amendment cases decided since you joined the court. I'd like to examine how constitutional principles have been applied in these decisions. The room grew noticeably quieter. This wasn't going to be a speech disguised as questioning, but a substantive examination of Kavanaugh's jurisprudence. In Americans for Prosperity versus Bonta, decided in 2021, you joined an opinion striking down California's requirement that charities disclose their major donors. The majority applied strict scrutiny, finding that even indirect burdens on association rights warrant the highest level of constitutional protection. Is that correct? Yes, that's a fair characterization, Kavanaugh nodded, appearing comfortable with this line of questioning. Yet just 3 months earlier, Crockett continued, in Cedar Point Nursery versus HED, you joined an opinion allowing significant restrictions on labor organizers' access rights, applying only rational basis review despite the obvious associational burden. Could you explain why donor privacy triggers strict scrutiny while worker organizing receives only minimal protection? Kavanaugh's expression changed subtly. Those cases involved different constitutional contexts. Congresswoman, Cedar Point primarily concerned property rights rather than pure speech rights. But Justice Kavanaugh, Crockett pressed, turning to a specific page in her binder. The union explicitly raised First Amendment association claims in their brief on page 37. They argued that organizing activities constitute core associational rights protected by the First Amendment. Yet the majority opinion, which you joined, dismissed these claims with barely a paragraph of analysis. She continued without pausing. Let me show you another example. In Kennedy versus Breton School District, you joined the majority protecting a football coach's right to pray on the field after games. The court emphasized that restrictions based on hypothetical concerns about student coercion were insufficient. Yet, in Fulton versus Philadelphia, decided that same term, you applied a completely different standard to Philadelphia's hypothetical concerns about discrimination. Crockett displayed side-by-side quotes from the two opinions on the large screen visible to everyone in the room. The comparison was striking. In Kennedy, the court rejected speculation about potential harms as insufficient to restrict religious expression. Yet in Fulton, speculative concerns were deemed sufficient to uphold restrictions on other types of expression. How do you reconcile these different approaches to similar constitutional questions? Kavanaugh shifted in his chair, visibly less comfortable. These cases involve complex balancing of different constitutional interests. The court carefully considers the specific context of each case. I understand cases have different facts, Crockett responded. But shouldn't the analytical framework remain consistent? Let me be more specific. She turned to another tab in her binder. In Americans for Prosperity, you emphasized that even slight infringements on First Amendment rights must withstand strict scrutiny. Yet, in Tanzan versus Tanvir, involving Muslims placed on the no-fly list for refusing to become FBI informants, a serious burden on their religious practice, you joined an opinion applying only intermediate scrutiny. She displayed another chart on the screen showing 8 First Amendment cases with starkly different outcomes based on who was bringing the claim. What constitutional principle explains why corporate donations receive more protection than religious exercise by religious minorities, or why a coach's public prayer gets more protection than a protester's right to assemble? The hearing room was now completely silent. Several legal reporters were frantically taking notes, recognizing that Crockett was raising substantive inconsistencies rarely addressed so directly in congressional hearings. Kavanaugh, visibly uncomfortable, attempted to regain his footing. Congresswoman, these are complex constitutional matters that require significant legal expertise and careful analysis of precedent. I don't think they can be reduced to simple comparisons. The condescension in his tone was unmistakable, and it would prove to be a critical mistake. Several committee members exchanged glances, recognizing his dismissive implication that Crockett lacked the legal knowledge to engage on these issues. Crockett paused briefly, her expression unchanged. Justice Kavanaugh, before joining Congress, I litigated constitutional cases for 15 years, including First Amendment claims before the Fifth Circuit. I'm quite familiar with how constitutional principles should work in practice. Without raising her voice or changing her professional demeanor, she continued, "My question isn't about different facts. Every case has different facts. I'm asking about consistent application of constitutional principles. Something you yourself have emphasized is essential to the rule of law." She turned to the next page in her binder. "Let me focus on a specific principle you've championed. In your 2012 Harvard Law Review article, you wrote that the cardinal sin of First Amendment jurisprudence is viewpoint discrimination, treating speech differently based on who is speaking or what they are saying. The mention of his pre-confirmation academic writing clearly surprised Kavanaugh. Few members of Congress had shown such detailed knowledge of his legal scholarship. "I'm familiar with my article," he responded cautiously. "I'm glad," Crockett replied, "because I've analyzed every First Amendment case decided since you joined the court. In cases involving religious organizations, corporations, or conservative advocacy groups, you voted to apply strict scrutiny 100% of the time. But in cases involving protesters, labor unions, or civil rights organizations raising identical constitutional claims, you've applied intermediate or rational basis scrutiny in 91% of cases." The data visualization appeared on screen, showing the stark pattern in color-coded columns. The impact was immediate and powerful. Several committee members, including Republicans, leaned forward with interest. "This pattern," Crockett continued, "directly contradicts the viewpoint neutrality principle you advocated in your Harvard article. It suggests the determining factor in your First Amendment analysis isn't the nature of the government restriction, but the identity of the speaker and the content of their speech." She then displayed side-by-side excerpts from two Kavanaugh opinions written just 4 months apart. In these opinions, you applied completely different analytical frameworks to nearly identical government restrictions on speech. The only meaningful difference was who was speaking and what they were saying. Kavanaugh, visibly flustered, adjusted his tie. Judicial opinions addressed the specific cases before the court. Congresswoman, different contexts required different analyses. Different contexts, certainly, Crockett acknowledged. But different constitutional principles? Your own writings emphasize that while applications may vary, the fundamental principles must remain consistent regardless of who is speaking. The confrontation reached its climax when Crockett opened her final binder. "Justice Kavanaugh, I want to be very specific about the inconsistency I'm identifying. In Americans for Prosperity, you wrote that even minor burdens on association must survive strict scrutiny. That's a direct quote. Yet in Cedar Point Nursery, you joined an opinion applying rational basis review to a significant burden on labor organizing, which is also a form of association protected by the First Amendment." She paused, then delivered her most powerful point. The First Amendment doesn't protect only popular speech or powerful speakers. It doesn't have a carve-out for certain viewpoints. The same constitutional principles must apply whether the speaker is a corporation or a protester, a religious organization or a labor union. When the court applies strict scrutiny to protect speech it favors while applying minimal scrutiny to speech it doesn't, it undermines the very neutrality that legitimizes judicial review. Kavanaugh attempted to pivot. The court strives to apply constitutional principles even-handedly. Reasonable minds can differ on specific applications. Reasonable minds can certainly differ, Crockett replied. But principles shouldn't differ depending on who's speaking. That's the essence of viewpoint neutrality, a concept you've championed in your own writings, but that your voting record on the court has not consistently reflected. As phones captured what was clearly becoming a historic exchange, Crockett turned to one final exhibit. "In these two cases," she said, showing a split screen of opinions, "you personally wrote that the history and tradition of the First Amendment must guide its interpretation. Yet, you applied completely different historical analyses depending on the speakers involved. For religious speakers, you examined history at a high level of generality. For political protesters, you required specific historical precedents." She looked directly at Kavanaugh. "My question is simple. What constitutional principle justifies applying different standards of historical analysis depending on who is speaking or what they are saying?" The room held its breath. Kavanaugh, for perhaps the first time in his judicial career, appeared genuinely at a loss. After several seconds, he responded, "The court examines each case on its specific merits. Congresswoman, I believe my opinions have been consistent with constitutional principles, even if the specific applications vary. His response noticeably failed to address the specific contradictions Crockett had identified. Several journalists were already typing frantically on their phones, recognizing the significance of a Supreme Court justice, unable to explain apparent inconsistencies in his own jurisprudence. As Crockett's time expired, the chairman said, "The gentlewoman's time has ended, but the witness may briefly respond to her points." Kavanaugh gathered himself. "I appreciate the Congresswoman's questions and her obvious preparation. The court takes its obligation to apply constitutional principles consistently very seriously. What may appear as inconsistencies often reflect the complex interplay of different constitutional values in different contexts." His generic response stood in stark contrast to the specific documented patterns Crockett had presented. The Supreme Court justice, known for his detailed and articulate opinions, had effectively been rendered speechless by precise, substantive questioning that exposed contradictions in his own jurisprudence. As the hearing moved to the next questioner, cameras caught several senior committee members approaching Crockett with evident respect. A veteran Republican congressman who had clerked on the D.C. Circuit was overheard saying, "That was the most substantive constitutional analysis I've seen in this committee in 15 years." The impact of the Crockett-Kavanaugh exchange was immediate and far-reaching. Within hours, video clips of the confrontation spread across social media. Hashtag Crockett questions and hashtag Kavanaugh contradictions became trending topics nationwide, generating over 25 million views in just 24 hours. What made this exchange different from typical viral political moments was its substantive nature. Major news outlets moved beyond reporting on the personal dynamics to analyze the constitutional issues Crockett had raised. The Washington Post published a front-page article titled "Scrutiny Standards: The Court's Uneven Application of First Amendment Principles," which confirmed many of the patterns Crockett had identified. Legal scholars from across the political spectrum weighed in on the substance of the exchange. Harvard Law professor Lawrence Tribe tweeted, "In 50 years of constitutional law, I've rarely seen such a precise challenge to the court's First Amendment jurisprudence." Congresswoman Crockett identified genuine inconsistencies that deserve serious engagement. Even conservative legal figures acknowledged the significance of her critique. Former federal Judge J. Michael Littig wrote, "While I support many of the court's recent decisions, Representative Crockett's analysis of inconsistent scrutiny standards raises legitimate concerns about the principled application of constitutional doctrine." Her questioning was remarkably substantive. CNN assembled a panel of First Amendment experts who largely confirmed Crockett's analysis. "What made this exchange so powerful," said constitutional scholar Akilah Lamar, "was that she wasn't making political points. She was identifying genuine jurisprudential inconsistencies, using the justice's own words and principles." The impact extended beyond media coverage. Law schools across the country requested permission to use video of the confrontation in constitutional law courses. Georgetown Law Center announced a symposium titled "Scrutiny and Consistency in First Amendment Jurisprudence," inspired directly by the issues Crockett had raised. Several prominent law reviews commissioned special issues examining the scrutiny disparities she had highlighted. For Justice Kavanaugh, the hearing represented a significant professional challenge. Court watchers noted that his dismissive response to Crockett's initial questions, followed by his inability to substantively address her critique, damaged his reputation as a principled jurist. The New York Times published an analysis of Kavanaugh's voting record that confirmed the pattern Crockett had identified. He had indeed applied different levels of scrutiny, depending on who was before the court. Within the Supreme Court itself, the exchange prompted internal discussions. According to sources who spoke anonymously to The New Yorker, several justices had privately acknowledged that Crockett's analysis had identified real tensions in the court's recent First Amendment jurisprudence that needed to be addressed. "There's a genuine concern among some justices," one source told The New Yorker. This exchange exposed vulnerabilities in the court's approach to First Amendment cases. When a member of Congress can identify such clear patterns of inconsistent scrutiny, it raises questions about the court's commitment to neutral principles. For Congresswoman Crockett, the hearing transformed her national profile. Law schools and bar associations invited her to speak about constitutional interpretation. The American Constitution Society asked her to deliver a keynote address on neutral principles and constitutional interpretation. Major legal organizations representing diverse attorneys highlighted her performance as evidence of the importance of different voices in constitutional dialogue. The National Bar Association established a Jasmine Crockett Prize for constitutional analysis for law students who demonstrate exceptional ability in identifying inconsistencies in constitutional doctrine. What Congresswoman Crockett demonstrated wasn't just individual brilliance, said the dean of Howard Law School in a widely shared editorial, but the value of perspectives from those who've actually represented everyday Americans in constitutional cases. Her practical experience as a civil rights attorney gave her insights that purely academic perspectives often miss. The exchange changed how Congress approached its oversight role regarding the Supreme Court. Other committee members began adopting what some called the Crockett model of questioning, focused on substantive legal analysis rather than political talking points or personal attacks. Perhaps most significantly, the confrontation had a direct impact on Supreme Court jurisprudence. 3 months later, during oral arguments in a major First Amendment case involving protest rights, several justices, including Kavanaugh, asked questions specifically addressing the consistency of scrutiny standards across different types of speakers. When the decision was announced, legal scholars were surprised to see Kavanaugh's concurring opinion, which directly addressed the issues Crockett had raised. While not citing her by name, his opinion acknowledged that the court must be vigilant in applying consistent standards of scrutiny regardless of the identity of the speaker or the popularity of the message, a fundamental principle of First Amendment jurisprudence. 6 months after the hearing, when the court issued its decision in another First Amendment case, commentators noted a marked shift in Kavanaugh's approach. His opinion explicitly stated that the level of scrutiny must be determined by the nature of the government action, not by the identity of the speaker or the content of their message. Almost exactly the principle Crockett had pressed him to acknowledge. For everyday Americans, particularly those from backgrounds traditionally underrepresented in legal institutions, the Crockett-Kavanaugh exchange became a powerful symbol of how expertise and preparation can overcome assumptions and stereotypes. Social media filled with comments from young women of color, expressing inspiration at seeing someone like Crockett hold one of the nation's most powerful legal figures accountable through sheer constitutional knowledge. Watching Congresswoman Crockett methodically expose these contradictions showed me what's possible, wrote a first-year law student in a viral post. She didn't raise her voice or get emotional. She just exposed the inconsistencies using their own words and principles. 1 year after the hearing, the Yale Law Journal published a comprehensive study of the Supreme Court's application of scrutiny standards across different categories of First Amendment cases. The study, which confirmed many of the patterns Crockett had identified, concluded the court's inconsistent application of scrutiny standards based on speaker identity raises profound questions about its commitment to viewpoint neutrality, a principle that lies at the heart of First Amendment jurisprudence. As for Justice Kavanaugh, while he never directly acknowledged the impact of the exchange, court watchers noted a distinct evolution in his approach to First Amendment cases. His subsequent opinions showed greater attention to consistent application of scrutiny standards, with one legal scholar observing, Kavanaugh's recent jurisprudence demonstrates a heightened awareness of the need for principled consistency across different categories of speakers, a significant development from his earlier opinions. The confrontation ultimately transcended a momentary exchange to become a case study in constitutional accountability and the importance of consistent principle in constitutional interpretation. Law schools now teach it as an example of effective congressional oversight and the value of substantive dialogue between branches of government. If this story of knowledge prevailing over power inspired you, don't forget to like this video and subscribe to our channel for more content that shows how preparation and expertise can make a real difference. Share in the comments your thoughts about times when someone's deep knowledge completely changed a debate or confrontation. Your experiences help build our community of people who value substance over style and truth over talking points.